Welcome to Explified. The Right to Information Act (RTI) was an act passed on 15th June 2005 by the Parliament of India, which came into force on 13th October 2005. The act guaranteed any and every citizen the freedom to demand information from all public authorities and undertakings which they were bound to produce expeditiously or within a period of 30 days. After an 82-year-long movement, the RTI Act was finally passed unanimously by both the houses of the Parliament. It marked a new age of unfettered information and ensured accountability and responsibility from public institutions by abolishing the previous Official Secrets Act of 1923, which severely restricted the passage of information in India. As once famously stated by Thomas Jefferson, referred as the founding father of the United States of America, information is the currency of a democracy. It should be the fundamental right of every law-abiding, tax-paying citizen of a country to know how his elected government functions and allocates resources and public funds. Thus, initiating the formation and functioning of a government and public institutions which are answerable to the public is of paramount importance in establishing a successful, ethical, and representative democracy. In light of the recent amendments initiated in the Right to Information Act by the current NDA government, which empowers the government to prescribe terms of office and salaries of state information commissioners and central information commissioners, the intricacies of the original RTI Act have come to light and become a topic of discussion. In this video, we discuss the pros and cons of the provision of a right to information and how the newest amendments might affect the manifestations of that right. Right to information in India found its premise in the Universal Declaration of Human Rights adopted in 1948, which gave everyone the right to seek, receive information and ideas through any media and regardless of frontiers. The International Covenant on Civil and Political Rights 1966 also provided a basis for the formulation of this act. Its tangible entry to India was, however, shaped entirely by the judgment of Supreme Court in Mr. Kulwal versus Jaipur Municipal Corporation case, where the argument of access to information being a fundamental right was first raised. The Supreme Court ruling was unanimously along the same lines, with the central idea being propagated that if the people don't know, how will they speak? They said that freedom of speech and expression, which was a constitutionally mandated fundamental right from the very inception of the Constitution, cannot be fully exercised unless the general people possess perfect knowledge. When it finally came into force in India in 2005, these rights were awarded to all citizens across the states and union territories of India bearing Jammu and Kashmir. The RTI bases itself on two basic concepts. One, the right of the public to request access to information, and two, enforcing the conformable duty of government institutions to provide that information as fast as possible unless specifically permitted for exclusion, thus binding both private and public agents of society together in its web. As dictated by the Supreme Court, the Right to Information Act was formally stated to include the right to receive, seek, and impact ideas and information, right to information and obligations of public authorities, right to commercial speech and commercial information, and right to inform and be informed. A Central Information Commission was also set up to safeguard the sanctity of the laws and assure their hassle-free implementation. Several factors contributed to make this law into a reality. The ever-increasing modernization of the Indian social economy and awareness about public issues, pressure from international courts of justice and global organizations, and the huge number of corruptions and scandals taking place in the government. The primary objectives of the Act were to empower the citizens, to promote transparency and accountability, to contain corruption, to enhance democratization of the society by involving people in representative democracy, containing the spread of speculative rumors and misinformation due to an information asymmetry between the government and the people. Advantages of the RTI Act: unrestricted access to information creates better informed citizens who is more aware and better equipped to understand the proceedings around him and perform his duties accordingly. It encourages increased participation in public matters and also empowers the public to make rational and informed choices which would best suit their and a collective social interest. It can build a sense of trust and confidence in the government by enforcing transparency. All people, irrespective of their education or financial background, can demand to know whether their government is functioning properly and if the promised policies are being undertaken or not. It acts as a fail-safe for the abuse of indiscriminate power by government officials or ministers in office. The fear of being accountable serves a deterrent to unlawful or under-the-table practices. Disadvantages of the RTI Act: a central problem of the RTI Act is misuse. Seeking out public information which has no relevance serves as nothing but a harassment and time waste for the concerned authorities. Owing to the vast illiteracy and backwardness in society in a majority of the country, exercising the RTI sometimes become a hassle. Due to the overburdening set in motion by indiscriminate requests of information access, sometimes the wrong information can be doled out, which can lead to issues of distrust and carelessness. In some cases, the RTI has had a counterintuitive effect. For example, in order to prevent questioning, some political parties resort to black market channels and off the records transactions to fund their electoral campaigns, so that even if an RTI is issued, it turns up nothing. What do the new amendments speak about? The amendments to the RTI seek to alter the pay and allowances of information commissioners who currently enjoy benefits equivalent to election commissioners. This move has been hailed by activists and academians as exclusionary and is predicted to dilute the transparency and autonomy of the Chief Information Commissioner. Another very controversial change to the laws have been the decision to remove political parties from the purview of the RTI. This is alleged to increase undocumented sources of party funding and reduce accountability of these parties to the people. The amendments might fundamentally weaken the very institution of the RTI by going against the basis of what it stands for. Information isn't supposed to be skewed and incomplete. It is supposed to represent the truth, no matter how unpleasant. The need of the hour is for the government to indulge in dialogue with the validity and ethical concerns regarding the amendments with their critics and sort out an amicable solution which guarantees sufficient autonomy to the Information Commission while also meeting the aspirations of the government.